Hey guys, how are you? Happy New Year to all of you. As I stated on my blog before, I'm going to try and do more and more video blogs to deal with a lot of the issues that you guys asked me about. Reason being that I want to take real world examples and give that to you, and it's a little bit tougher to do when you're typing it out. And it seems to be a little bit more interesting if I'm on video and you can actually see me discuss this. So our inaugural sort of blog post for 2013 deals specifically with what happens in terms of attorney conduct. What I mean by that is just as important for your attorney to be able to behave in the proper manner with the trustee during the pendency of the bankruptcy as it is for you to behave appropriately. Here's what I mean by that. It's kind of our obligation, it's something that we need to do in every bankruptcy case, is to make sure all the documents that the trustee requests are sent to them well in advance. Now, when I say well in advance, I literally mean about 10 days, on the shorter side, to as much as 2 to 3 weeks before the meeting. Tax returns, bank statements, pay stubs, everything else. We go to bankruptcy meetings basically every single day in court, and what we find is that there's some attorneys out there that, for whatever reason, come unprepared. That's a huge red flag for your case, and I'll tell you why. If all of your stuff is prepared, if all of your stuff, and you've provided this to your attorney, is sent over to the trustee well in advance of that meeting, the trustee will likely not bring up sort of issues when they can actually check it out before they get to court. So, in other words, let's say you have a car that you own and it's listed on the petition, but there's nothing that was sent over to the trustee that states how much the car is actually worth. How does the trustee know whether or not he or she can take that car and sell it? They don't, realistically, without that number. That appraisal, in the form of a Kelly Blue Book valuation, is almost always sent prior to the meeting of the creditors because, again, the attorney wants the trustee to know that this car is worthless or that it's protected under the deductions that we can take in New York. If they don't receive that, they're apt to keep the meeting open, which means you may have to go back again, which means there may be more questions. The tone of the trustee certainly changes as well if they don't get documents. If they don't receive tax returns, if they don't receive bank statements, if they don't receive these things, they get really pissy, as they should. They have to deal with 40 or 50 of these cases on a daily basis, and they're not concerned with why the attorney hasn't sent it to them, etc. So, a lot of times people talk about what the client's responsibilities are in a case like this. But the attorney also has to step up to the plate themselves. They have to be sure to be prepared at all times for all questions that the trustee may have and produce all the documents that the trustee wants. Without that, it's kind of like going to the dentist and getting a drill without any kind of Novocaine or anything else. I mean, it's pretty painful, and we've seen it happen. Sometimes the trustee will go through 30 or 40 cases, and then the 41st case, you come up, and unfortunately you don't have anything stating how much your house is worth. And you come in and you basically say, look, my neighbor said it's worth X, and the trustee goes crazy. They don't care. They've dealt with 40 cases already. They want to finish up their calendar, and they think that you and your attorney should know that you should have brought in something that values your house, an appraisal or comps or anything else. So it's really important that you speak to your attorney prior to this and make sure that they're aware of what the trustee needs, or at least when you interview an attorney and you speak to them during a consultation, you ask them questions about how soon prior to the bankruptcy do you actually send them the documents? Which documents do you send? And is there any way you can confirm to me that you've actually sent them? Trustees, I should say attorneys, may find this annoying, but look, it's your bankruptcy case. It's super important for you. And so the last thing you want to do is not come out of that meeting and have the meeting actually closed, but have to come back again. So stay on top of your attorney. If you're interviewing attorneys, make sure they give you straight answers as to that, and you should be in much better shape. Look forward to talking to you guys soon.